In this section, I will be explaining more details on estate planning. What is estate planning? Estate planning is a process of disposing of an estate after one's death according to Sharia and civil law. What are estates? There are two categories of estates which consist of assets and liabilities. There are two types of assets, which are movable assets, which consist of cash, shares, bank savings, EPF savings, and insurance claims, while immovable asset consists of land, houses, and buildings. Liabilities. Liabilities is a thing for which someone is responsible, especially an amount of money owed. Next, we move on to the categories of estate. There are two categories of estates, which are testate estate and intestate estate. Testate estate. When a person dies and he or she leaves a will, it is called as testate estate. The will be administered according to his or her wishes. Intestate estate. If he or she does not leave any will, then his or her estate will be administered as an intestate estate. It will also be administered through the summary administration, small estate, or high court. Summary administration. Only ARB is empowered to administer an estate summarily under the Public Trust Corporation Act 1995. Estates are administered without having to apply for letters of administration from the High Court. This power is exercised due to whether there is a will. The movable property is in Malaysia. Value of property does not exceed 600,000 ringgit Malaysia. No person entitled to apply for a grant or probate. No petition for letters of administration pending. There is a person making a claim on property. Small estate. If the estate consists of movable and immovable asset not exceeding the value of 600,000 ringgit Malaysia, ARB will administer the estate by making an application to the Land Office for a distribution order or for the appointment as administrator of the estate. High Court. If the estate exceeds 600,000 ringgit Malaysia, ARB will administer it by applying to the High Court for the letters of administration and distribute the estate. What must be settled first before distribution to the heirs are made? To pay for his funeral expenses, to discharge all his obligations relating to zakat, various kafarah or penalties for oath, zihar, caution whilst fasting in the month of Ramadan, caution whilst in the state of ihram during Hajj or Umrah. To settle all his debts to his fellow beings. The settlement of such debts shall include the performance of Hajj on his behalf if he had not already done so in his lifetime, and the payment of Mahr if payment had not already been made. To execute his will. A will is not for a person's heirs. Testamentary disposition, distribution of remaining estate. Persons not entitled to get inheritance. A fugitive slave who has fled away from his master. One who has murdered one's ancestor intentionally or unintentionally. One who professes a religion other than Islam. What is a will? A will is a document in writing that states a person's intention as to how his or her estate is to be administered and distributed after his or her death. Hibah. A Muslim could hibah his or her estate to anybody within living duration, whether partial or all of the estate, for example, by transferring name in the house title, car, or land. Fara'id. Fara'id, or as known as the law of inheritance in Islam, is a science dealing with the law pertaining to devotional acts based on the Sharia in respect of the wealth of a person after the certainty of his or her death. How wills could be revoked. Marriage. A will is revoked by a marriage or remarriage. Divorce or separation does not revoke a will. Destruction. A will is revoked when the testator destroys the will physically with the intention of revoking it. Accidental destruction by a third party does not constitute revocation. A later will. A subsequent will would automatically revoke an earlier will, whether or not a revocation clause is included in the later will. Conversion to Islam. A will is revoked when a non-Muslim person converts to Islam because the distribution of his or her estate will automatically follow the varied distribution. Parties involved in a will. Testator is a person who writes a will. Executor, a person or a trust corporation appointed by the testator to administer his or her estate. Trustee, person or trust corporation appointed in a will to hold on trust for beneficiaries who inherit assets in a will. Guardian, a person appointed to take care of the welfare of minor children. Beneficiaries, a person or entities who receive gifts under a will. Two witnesses, two independent parties who witnesses the testator signing the will. Different class of heirs: Zawul Furud, Zawul Arham, Asabah. Zawul Furud are those persons who have a right to definite shares in asset left by the deceased. Asabah, when the heirs of the first group have received their respective shares, the residue of the assets fall to the share of those relatives. Zawul Arham, the last category of inheritors. There are 7 types of wills: individual will, mutual will, joint will, privilege will, Islamic will, which is also known as wasiat, holographic will, and living will. Harta sepencarian, property acquired by husband and wife. Trust. A trust is a legal obligation when an individual transfers the legal ownership of his assets to another person to hold for the benefit of the beneficiaries.